Hello friends, in the series on the income tax cases, today we will discuss a very important judgment of Principal Commissioner of Income Tax and another versus GALI JANARDHANA Reddy. This case has been reported in 454 ITR at page number 467. The matter has been decided by Karnataka High Court and the date of the judgment is 31st March 2023. The purpose of discussing this case is the importance of satisfaction note to be recorded by the assessing officer of the searched person. As all we know that whenever a search is conducted on an assessee and if the assessing officer of the searched person feels that some documents and information relates to the other person, then the assessment of other person can also be done under section 153C. But before issuing the notice to the other assessee under section 153C, it is very important and essential for the assessing officer of the searched person to record satisfaction in regard that these documents belong to the other assessee. The assessing officer of the searched person or the department who has made the search can have an idea that these documents belong to the other assessee at the time of the search itself, or at the time of making the assessment of the searched person, or at the completion of the assessment of the searched person, and after recording the satisfaction that these documents do not belong to the searched person and these documents belong to the other person, the satisfaction note is to be recorded, and then after that notice under section 153C is to be issued to the other assessee. In the present case, the notice for 7 years, 6 years plus 1 year, 6 years under section 153C and 1 year under section 143 subsection 3 was issued to the other assessee and assessment was made. It was the submission of the assessee that satisfaction was not recorded by the assessing officer of the searched person, so the assessments are null and void. It was the point of the assessing officer that the assessing officer of the searched person and the assessing officer of the other person is the same, so there is no need for recording the satisfaction. When the matter was before the CIT appeal also was not agreeing with the assessee, so the CIT appeal upheld the order of the assessing officer. When the matter came before the ITAT said that even if the assessing officer of the searched person and the other assessee is the same, in that case also it is the prime requirement before issue of notice under section 153C that the satisfaction note is to be recorded and it should be there in the file. Since this prime requirement has not been fulfilled by the department, so the assessment for the 7 years is null and void. Friends, in this case, one thing is more important, that what should be the date in case of other assessee for calculating the period of assessments. In case of the assessee who has been searched, the date of search is relevant. The department has to make the assessment for the 6 year previous to the previous year in which the search is made and for the year in which the search is made. Previous year section 153A and for the date for the year of the search under section 143 subsection 3. But in case of other assessee, the date of search will be that date on which the assessing officer of the searched person hands over the documents to the assessing officer of the other person, or the satisfaction note or the date of the satisfaction note prepared by the assessing officer of the searched person. So when this matter came before the High Court also said that the order of the ITAT is good and the assessment made by the assessing officer, which was upheld by the CIT appeal, are not good in law, and quashed all the assessments of the 7 years done by the department. The department has relied on the very celebrated judgment of CIT versus Gopi Apartment of Allahabad High Court, and that case has been reported in 365 ITR at page number 411. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax and another versus GALI JANARDHANA, Reddy. This case has been reported in 454 ITR at page number 467. The matter has been decided by Karnataka High Court and the date of the judgment is 31st March 2023. Thank you, friends.